Good evening, Shavua Tov, a good vach, good week to you, my holy sisters and brothers. It's great to be starting off the week right with some beautiful learning on a Saturday night, especially this coming week, which includes Yom Kippur. This is a time of examining our deeds. We should be heavily involved with examining our deeds, identifying those areas where we've strayed and where we need to do better, formulating that plan to do better, asking God to strengthen us and help us in doing better in those areas, asking for forgiveness from the people that we've harmed, and for the areas in which we've let God down, asking God to forgive us. But as we learned today from our rabbi, Rav Yekusiel Kalmanson, there's two kinds of Teshuva, repentance, atonement. One kind is, it's formal, it's proper, it's fulfilling your obligation of making an atonement, and just saying, I did wrong and I gotta do better. And it's another thing to say, okay, I've really messed up. But I've got to do better. And the reason I want to do better is if there's a person that I've hurt, it's because I care about you, because I love you. This behavior of mine, that let you down, I really regret it because I love you. And in areas where we've let down our Creator and where we know we could do better because we were sent in this world on a mission and given tools to fulfill that mission, and we've neglected to fulfill our mission. We're not doing our best to fulfill our mission. We're not doing our utmost to figure out what it is that we're supposed to do in this world, or if we know, to get it done. And so we say, God, I love you so much. You've given me everything. I have got to transform myself because I love you so much. That kind of teshuva can be absolutely transformative. And it actually makes it so that those areas where you strayed become an opportunity to create something that wouldn't have happened otherwise. And so the past, present, and future all come together in this kind of holy work. And may we all be blessed to make a successful atonement along those lines. Okay, where are we holding? First of all, let's light up the darkness. New wisdom candle. Getting started here. We get into the week of Yom Kippur. Who's with us on a Saturday night? Bill in Mid-Missouri, Stephen in New Hampshire, Melissa in Great Neck, James in Indianapolis, Bobby in Boston, Lou in Modine in Israel. Welcome, Lou. Larry in New York, Zach, I think outside Las Vegas. Always great to see you here, Zach. Bella in Florida, Stephen in Oklahoma, Paul in the Great Northwest, Venita in West Virginia. That's a new name. Welcome. Paul is saying Shavua Tov. Karen in Northern California, Sharon in New Jersey, Clarissa saying Shavua Tov. Laura's in Oklahoma. And over there on the YouTube side, Gigi in British Columbia. Welcome, everybody. We are holding by Daf Pei Zion, right? Page 87 is our page tonight here in Tractate Kesubos, the 15th volume of the Talmud. These are the laws of marriage contracts. Here in chapter 9, we're examining some of the rights of a husband in a marriage, which he could choose to waive. Can he waive all of them? What exactly is the language necessary so that he's actually waived a right that the Torah gives him? These are some of the questions we've been examining. We're now covering Mishnah number 4, which we read at the end of yesterday's class here in chapter 9. And that basically covers that a husband in his ketubah might waive the right to demand an oath be taken by his wife. When do you demand that someone takes an oath? If, for example, they're your employee, and a wife could become a husband's employee. She's not an employee because she's his wife, but if he runs a store, he owns a store, he might hire her as an employee to run the store. If he owns large properties, he might hire her to be the steward of some or all of those properties. Now she's functioning as an employee, even though she's also his wife. And an employer can demand of an employee to take an oath that he has not, stolen from his employer, that he has not been dishonest, that all his dealings have been scrupulously honest. That's one form of oath that can be taken. We'll see others. And so even though a husband normally, as we saw yesterday, does not have the right to demand that his wife take an oath that she has not stolen from her husband, because what kind of a marriage would that be if he's always suspicious of her? But if she takes on a job as an employee, then she could be asked to take such an oath. And there are other situations where oaths are taken. And as I pointed out several times in the last few days, it's so interesting what it means, that somebody's going to take an oath and therefore they're going to be trusted to receive or give money, right? I mean, that's really the sign of a God-fearing society, where you're going to say, okay, well, you took an oath, we believe you, because you wouldn't take an oath and then steal. And it seems like in modern times, a lot of people, are proven to be liars all the time. And it would seem like, forcing someone to take an oath and then on the basis of that distributing large sums of money might not work in today's society, because so many people are not God-fearing. So it's nice to see and to imagine what this kind of society was like in Talmudic times and biblical times. All right, so let's look at the Gemara on Mishnah number 4. We begin at the bottom of page 86b. The Gemara asks, what is the purpose of an oath? Meaning, what oath can a husband administer to his wife? Meaning, make her swear an oath. That's to administer an oath to someone means that you tell them, you take an oath, and then we can proceed to the next step. You must take an oath or we cannot proceed to the next step. So, what is the purpose of an oath? What oath can the husband administer to his wife that cause him to add this condition to her marriage contract, right? In the context that we're talking about of this Mishnah number 4, the husband is waiving his right to ever demand that his wife take an oath. But what kind of oath is he waiving the right to demand from her? Rav Yehuda said that Rav said. Now we're on 87a. This kind of oath is referring to a woman who became a steward during her husband's lifetime. So while they were married, while the husband was alive, she was not only his wife, but she took on the job of being a steward of one of his properties, right? A property manager. As it was common for a man to leave his wife in charge of his property while exempting her from taking an oath. He might demand that his other employees take oaths, but he'll exempt his wife from taking such an oath. And it might be that, at the beginning of their marriage, maybe he already had a bunch of properties and it was contemplated that she might become a steward of some of his properties. And so at the time that they got married, he said in the marriage contract, probably because she asked him to, I hereby waive my right to ever demand that you take an oath. Now, Rav Nachman said that Rabba Bar Avu said it is referring to a woman who claims that she received partial payment of her marriage contract. And then she must take an oath that she received no more than the amount that she admits to. And the Mishnah is referring to a husband who exempted his wife from taking that oath later in time after they got married. So Rav Mordecai went and said this halacha, this law, before Rav Ashi and asked him the following question. Granted, according to the one who says that it is referring to a woman who claims that she received partial payment of her marriage contract, it makes sense that it enters her mind that this might happen in the future at the time they're getting married, and that she might think this might happen in the future because she thinks perhaps I will require money while we are married, right? When does a marriage contract pay off? When they get divorced or the husband died. That's when the full amount of the marriage contract is due. But she might have need of that money before, the divorce or the death of the husband happens. So she thinks to herself at the time they're getting married, perhaps sometime in the future, I will require money and I will take what I need from my marriage contract up front. I'll take a partial payment of my marriage contract before it would actually come due. And so she therefore says to her husband before they get married, write for me that you will not administer an oath to me when I come to collect the rest of my marriage contract, right? She took some of it while they were still married, and then later they got divorced, let's say, and at that time she'll come, okay, I want to collect the rest of my marriage contract. And he'll say, well, you took some of it already. And she's like, that's right. You remember, you and I, we agreed, and I took, 20% of it a few years ago. So now give me the other 80%. And the husband at that time could say to her, well, take an oath that what we paid you is the 20%, and now I owe you 80%, because maybe his memory is not so good, and he wants her to take that oath. But she doesn't want to take oaths. People don't want to take oaths, because you might make a mistake when you make your oath, and then you'd be liable, right, for having lied when you took an oath before God. So it's better not to take oaths, and that's why she might have been advised at the time of getting married to get her husband to waive his right to ever administer oaths to her. So that might be one reason why she would have asked for that condition in their ketubah at the time that they got married. But Rabbi Mordechai is saying that makes sense in terms of, this idea of when is a wife, when does the husband waive the condition in the marriage contract that he could demand that his wife take an oath, maybe because she'll need some of that money up front. But as for this idea, however, according to the one who says that this idea of waiving the husband's ability to demand the oath is referring to the case of a woman who became a steward during her husband's lifetime of some of his properties, did she know before they got married that her husband would establish her as a steward to say to him, write for me that you will not administer an oath to me? Well, in a case that I just described before, right, that maybe the guy had a lot of properties at the time they got married and that it was already conceivable that could happen. But okay, in the normal course of things, she's not thinking he's going to appoint me as a steward at the time they get married, so it seems less likely that that's the condition, the situation they're thinking about when he's asked to waive that right at the time they're writing the ketubah. Now, Rav Ashi said to him, well, you teach this law of Rav Yehuda with regard to that part of the Mishnah, and therefore you find it difficult. However, we teach it with regard to this other part of the Mishnah, that if she went from her husband's grave to her father's house without handling her late husband's property, or in a case where she returned to her father-in-law's house and did not become a steward over the property at all throughout this period, then the heirs cannot administer an oath to her with regard to her actions in their father's lifetime, as the husband exempted her from an oath to the heirs. In other words, the husband said at the time that he wrote the ketubah, I will never force you to take an oath while I'm alive, right, for any reason. So he never forced her to take an oath while he was alive. Then he died. And if she handled the estate, right, like she is living in the house with him, he dies, so she's handling their property until it legally passes to his heirs. So then the heirs could say to her, take an oath that you have not, embezzled any property, misappropriated any property from our estate. But if after the husband died, she was hands off, she had nothing to do with the estate, other than to arrange the burial or something like that, well, then the heirs cannot force her to take an oath. And it was with regard to this statement that the Gemara asked, what is the purpose of mentioning the past? What is the purpose of mentioning the past? What oath would they have wanted her to take with regard to the past? The heirs might have said to her, take an oath that you never misappropriated, any property or funds from the estate in the past, meaning before the husband died. What oath would they have wanted her to take with regard to the past? And it was in response to this question that Rav Yehuda said, that Rav said, it was referring to a woman who became a steward of her husband's properties during his lifetime. So they couldn't ask her to take an oath with respect to normal husband and wife stuff, but since she became a steward of this property that they are now inheriting, maybe they could demand that she take a note that she didn't misappropriate anything during her stewardship. So the Gemara presents a dispute as to what is considered the past, first continuing the quote from Rav Yehuda. Rav Yehuda said, but they can administer an oath to her with regard to her conduct between her husband's death and his burial. And Rav Matana said, even concerning her actions between her husband's death and his burial, they cannot administer an oath to her. As the sages of Nehardea say, for the purpose of paying head tax and for payment to provide for children's sustenance and for burial, we sell property inherited by orphans without an announcement. In these urgent matters, the court is not particular about a possible loss incurred by the heirs. Similarly, the woman need not take an oath with regard to how she conducted her affairs for her husband's funeral, because in such a time of stress, she cannot manage her accounts in a precise manner. So you're not going to say to her, take an oath that you didn't misappropriate any funds and you didn't let any loss happen that shouldn't have happened because of your negligence, carelessness, greed, whatever. You're not going to make her take such an oath, because after her husband died, you can imagine the stress that people are under. We just went through this when my mom died. And that was expected. She was ill for a long time. But somebody dies suddenly. People are completely stressed out dealing with so many different things. They could easily make mistakes. So you're not going to make them take an oath about their handling of those affairs between the death and the burial. Presumably all they're dealing with is the burial, paying a tuition of school, things like that. They're not, getting greedy or making mistakes that are sort of considered abnormal for a person in that position. Now, Rabbi Achia said, if a husband wrote, not a vow and not an oath, right? So meaning, like in his ketubah, he wrote that he waives his right with regard to demanding of his wife neither a vow nor an oath, right? Not a vow and not an oath. Well, what does this actually mean, this legal language? This means that he cannot administer an oath to her, but his heirs can administer an oath to her. If he wrote in the ketubah, she is clear, i.e. exempt from a vow, and clear from an oath. Neither he nor his heirs can administer an oath to her. And this is because, in effect, this is what he is saying to her. You are clear from the oath. No matter who seeks to administer it to you, not me, not my heirs, you never have to take an oath with regard to my property. But Rabbi Yosef said that Rabbi Achia said the opposite ruling with regard to the second clause. If he wrote not a vow and not an oath, he cannot administer an oath to her. But his heirs can administer an oath to her. If he wrote, she is clear from a vow and clear from an oath, either he or his heirs can administer an oath to her. And this is because, in effect, this is what he is saying. Clear yourself from any suspicion by means of an oath. And here we can hear kind of, these long, distant echoes in the past of how much you need a lawyer, right? Because if you think that you can read a contract and understand the legal jargon as if it was plain English, you're mistaken, right? Legal jargon is legal jargon that has evolved over time to represent legal rights and obligations, and often they don't have the same meaning that they would mean in plain language. And here, even the sages themselves are arguing over what is the meaning of these legal terms in this contract, this marital contract. Rabbi Zakkai sent the following ruling to Mar Ukva from Eretz Yisrael. Whether he wrote not an oath, or whether he wrote clear from an oath, and whether he wrote not a vow, or whether he wrote clear from a vow, if the husband added the phrase, with regard to my property, he cannot, with regard to my property, if he wrote that phrase, then he cannot administer an oath to her, but his heirs can administer an oath to her. However, if he added the phrase, from these properties, then neither he nor his heirs can administer an oath to her. We wouldn't know that just from the plain meaning of the contract. You have to, be a scholar or a sage or, modern times a lawyer to understand this kind of legalese. Rav Nachman said that Shmuel said in the name of Abba Shaul ben Ima Miriam, right? So sometimes we have sages who their name, right? Like very often we see Rabbi Abba Bar Papa, right? So Rabbi Abba, the son of Rabbi Papa. And usually when, it's the son of, they mention the man's father, especially if his father was a sage also. But there are a few sages who receive a matronymic, right? It's their name, the son of their mother. And this is one of those cases. I'm sorry, where was I? Right. Rav Nachman said that Shmuel said in the name of Abba Shaul ben Ima Miriam, whether he wrote not an oath, or whether he wrote clear from an oath, and whether he wrote not a vow, or whether he wrote clear from a vow, and whether he added from my property, or whether he added from these properties, neither he nor his heirs can administer an oath to her according to the letter of the law. However, what can I do? As the sages said, that one who comes to collect a debt from the property of orphans may collect it only by means of an oath. Therefore, she is compelled to take an oath in any case involving a claim from the orphans, right? So what's an orphan under Jewish law? It's somebody who has lost a parent. Even if only one of your parents has died, you are considered an orphan under Jewish law because parenting is a two-person job. Once you're an orphan and you are an heir, right? You're not always, but in this case, if you're an heir, you inherit from the father. So if the widow now comes to claim property for herself that has become the property of an heir, then even though the husband in his ketubah included the condition that he waives his right to ever demand an oath from her, and he sort of makes that condition binding on his heirs, nevertheless, if the woman comes to claim property that belongs to an orphan, she's going to have to swear an oath that she's entitled to it, because that's the general law about removing property that belongs to the orphans. And that's just a feature of Jewish law to protect its most vulnerable members, or the most vulnerable people in society, right? It would be orphans who have inherited property, and unless the court protects them, unscrupulous people could come and take it from them. And some say this law in the form of a baraisa, not as a quote from an Amora, meaning a rabbi from the Talmud, but rather a quote from a Tana, a rabbi of the Mishnaic period. The Mishnaic period. So Abba Shaul ben Ima Miriam said, now as in a baraisa rather than than Gemara. So Abba Shaul ben Ima Miriam said, whether he wrote not an oath, or whether he wrote clear from an oath, and whether he wrote not a vow, or whether he wrote clear from a vow, and whether he added from my property, or whether he added from these properties, whatever legalese he used, neither he nor his heirs can administer an oath to her according to the letter of the law. However, what can I do? As the sages said, that one who comes to collect a debt from the property of orphans may collect it only by means of an oath. And the Gemara comments, Rav Nachman said that Shmuel said, the practical halacha, the law, is in accordance with the opinion of the son of Ima Miriam. Who was Ima Miriam? Unfortunately, we don't know. The note about this, the identity and time of this sage, Abba Shaul ben Ima Miriam, are unknown. The honorary title Abba, meaning father, is an early title that may predate the usage of the title rabbi. He may have been called by his mother's name in order to distinguish him from other sages of the same name, such as the famous Abba Shaul, who appears elsewhere together with him, or Abba Shaul ben Botni. His mother's appellation, Ima, which means mother, was likewise an honorary title for an important woman. There are several sages called after their mothers who were women of importance in their generation or who had a famous lineage. And that concludes our discussion of Mishnah number 4. Here's Mishnah number 5 in chapter 9. A woman who vitiates her marriage contract by acknowledging that she received a partial payment can collect the rest of her marriage contract only by means of an oath. Similarly, if one witness testifies that her marriage contract is paid, she can collect it only by means of an oath. Right? Normally, she can collect her marriage contract. Right? If a woman is normal situation, she got married, they had a ketubah, they were married for a while, and then they got a divorce, or the husband died, so then she collects her marriage contract. But if she already collected a partial payment of the marriage contract, now she has to swear an oath as to how much she collected in order to collect the rest. Likewise, if one witness comes forward and says, you received your marriage contract already, I saw it, then she can swear an oath and collect the rest. Why? Because if two witnesses came forward and said, you already received your marriage contract, then she'd be in a world of trouble. We established a matter by two witnesses. Here there's only one witness, but it's enough to cast doubt on the situation, and that's why she swears an oath to collect the rest. In any case, where she seeks to claim her marriage contract from the property of orphans or from liened property that has been sold to a third party, remember that she has a lien on all of her husband's property. So if at the time he dies or they divorce and there's not enough money in his estate or in his property to pay her marriage contract, but if he has recently or at any time sold property, she can get that back from the purchaser because she had a prior lien on all of his property to make sure he pays his marriage contract. So in any case where she seeks to claim her marriage contract from the property of orphans or from liened property that has been sold to a third party, or when not in her husband's presence, because like he went away overseas, then she can collect it only by means of an oath. Now the Mishnah elaborates. With regard to a woman who vitiates her marriage contract, how so? How does this situation arise? If her marriage contract was 1,000 dinars, and her husband said to her, you already received your marriage contract, and she says, I received only 100 dinars. So then she has made a partial admission, and she can collect the rest of her marriage contract only by means of an oath. If one testifies that her marriage contract is paid, how so? If her marriage contract was 1,000 dinars, and her husband said to her, you already received your marriage contract, and she says, I did not receive payment, and one witness testifies about the marriage contract that it is paid, so she can collect it only by means of an oath. And what about liened property? How does this situation arise? If, while they were married, the husband sold his property to others and she comes to collect her marriage contract from the purchasers, she can collect it only by means of an oath. She may seize property from the purchasers because her husband's obligation undertaken in the marriage contract predates his obligation in the document of sale, right? She had a prior lien. From the property of orphans, how so? If the husband died and he left his property to orphans, so she comes to collect her marriage contract from the orphans, and she can collect it only by means of an oath. Or when not in his presence, what is this situation? If he went to a country overseas and sent her a bill of divorce so that she collects her marriage contract when he is not around, not in his presence, so she can collect it only by means of an oath. Now, Rabbi Shimon says whenever she claims payment of her marriage contract, the heirs administer an oath to her. And if she does not claim payment of her marriage contract, the heirs do not administer an oath to her. That's Mishnah number 5, 187b. Here comes the Gemara. Rami Bar Chama thought to say that the oath of a woman who vitiates her marriage contract is an oath by Torah law, which is the oath of one who makes a partial admission, as the husband claims that he paid her 200 and she concedes to him with regard to 100. This is a partial admission of the claim. And the principle is that whoever admits to part of a claim must take an oath according to Torah law in order to receive the remaining amount. Rava said there are two answers in the matter in refutation of your argument. One response is that anyone who is obligated to take an oath that is enumerated in the Torah takes an oath and does not pay. The purpose of an oath is for someone to say, I don't owe you any money. So I take the oath and now I don't pay. But in the situation we're talking about, she takes an oath, I've received only part of the money that you owe me. I swear an oath as to how much I received. Now pay me the rest. Normally you take an oath in order not to pay. Here she's taking an oath in order to receive, right? And so that seems to be unusual. So Rava said there are two answers in the matter, right? So the first is normally an oath, you take an oath in order not to pay. By Torah law, one takes an oath only to exempt himself from payment. But in this case, she takes an oath and then receives money. And furthermore, there is a principle that one does not take an oath with regard to a denial of a lien on real property, on land. The oaths of the Torah apply only to movable property, not land. And this means that if a claim involves a lien on land of any form, the oath of a partial admission does not apply. And a marriage contract includes a lien on land. Rather, says Rava, this oath that we're talking about here is not an oath by Torah law that you received a partial payment and now you want to receive the rest. This is an oath by rabbinic law. What's the difference? They both have the force of law, but we've seen differences over time that a law by, if it's something by Torah law, then in cases of uncertainty, we're stringent. If there's a case of uncertainty in a matter involving rabbinic law, we are lenient. That's a general difference between Torah law and rabbinic law. Also, we draw a fence around Torah law by adding rabbinic decrees, but we don't draw a fence around rabbinic decrees by adding further rabbinic decrees. That's another difference. So says Rava, this oath that you're talking about, that the wife will swear if she received a partial payment, that she received that amount and no more, this oath is by rabbinic law. It was instituted because the one who pays is precise, and he recalls that he paid his debt, whereas the one who was paid is not precise. When the husband claims to have paid her, he remembers clearly what happened, and therefore the sages impose the obligation of an oath upon her so that she should be precise and remember exactly what occurred. When people are swearing an oath as to a legal matter, they're going to be careful because they're God-fearing people and they don't want to make a mistake when swearing an oath. So they're going to be very diligent to recall exactly what was going on. They're not just going to blurt out that oath. A dilemma was raised before the sages. In a case where a woman vitiates her marriage contract by accepting partial payment in the presence of witnesses, what is the law? Do we say that if it is so, that he has paid her the rest of the marriage contract, he would have paid her in the presence of witnesses, and since he has no such witnesses, this is proof that she never received the rest of the money, and therefore she's exempt from an oath? Or perhaps he simply happened to have witnesses when he made the first partial payment, but he gave her the rest without witnesses, and therefore she must take an oath with regard to the remainder of the sum. Right? She's saying, my ketubah payment is 1,000 dinars. You gave me 100 dinars. Now give me 900. He says, I gave you 100 dinars in the presence of witnesses, and then a year later, I gave you the rest of the 900, or I gave you another 500. And she says, where are your witnesses that happened? He says, I don't have witnesses. I had witnesses the first time. I didn't have witnesses the second time, but I gave you the money. She says, you didn't give me any money. We make her take an oath because she already admitted that she received a partial payment the first time, but we're going to make her take the oath about this second payment. Or the Gemara is asking here, well, wait, she had witnesses the first time. The husband had witnesses the first time. Now he's claiming he gave her a second payment and there's no witnesses for that. Maybe she's exempt because this is a guy who gets witnesses when he makes partial payments. So what's the answer? The Gemara suggests, come in here, proof about this matter from a Mishnah in Tractate Shavuos 44b. Anyone who is obligated to take an oath that is enumerated in the Torah takes an oath and does not pay. So here you would think, well, the husband takes an oath, I already paid you, and then he does not pay. But, says that Mishnah in Shavuos, anyone who is obligated to take an oath in the Torah takes an oath and does not pay. And these, now there's a few specific cases where the other one takes an oath and receives payment. Who is that? The hired worker who demands his wages from his employer, and one who was robbed, and one who was injured, who claims compensation from the one who caused him damage. And if the one opposing him, meaning the other litigant in a case, was supposed to take an oath, but he is suspected with regard to oaths, and so then the one who is not suspected can take the oath and receive money. Also a storekeeper who makes a claim on the basis of what is written in his notebook. He keeps a journal of what his customers owe him. If he now wants to come and say, pay me, and the customer says, I never took that merchandise, I don't owe you. So the storekeeper would swear an oath and then receive money. And who else? One who receives partial payment of his document, not in the presence of witnesses. So that sounds like the wife who received a partial payment on her ketubah. So she will swear an oath and receive the rest. But note that this says one who receives partial payment of his document, not in the presence of witnesses. Conclude from this last clause that if one received partial payment of a document not in the presence of witnesses, then yes, he is obligated to take an oath. But if he received the payment in the presence of witnesses, then no, he is not obligated to take an oath in order to receive the rest. Now the Gemara refutes this argument. The Mishnah is speaking utilizing the style of it is not necessary. What is the style of it is not necessary? In this case, it is not necessary to state that if part of the marriage contract was paid in the presence of witnesses, she certainly requires an oath. However, if a partial payment was made not in the presence of witnesses, one might say that her partial admission would be like one who restores lost property. Since there are no witnesses that the husband paid anything, when she concedes to part of the claim, it is as though she has restored him a lost item, and she should therefore take the rest of the money without an oath. In accordance with the law that one who returns lost property does not have to take an oath that he did not appropriate part of what he found for himself. So the Tana therefore teaches us that even in this case, an oath is required. A dilemma was raised before the sages with regard to a woman who vitiates her marriage contract, meaning she took a partial payment, and details with precision every sum of money that she received, specifying not only large sums of money, but also sums so small that they amounted to less than the value of a peruta, like a penny. So what is the law? Since she's so scrupulous, do we say that since she is precise to such an extent, she must be telling the truth? Or do we say perhaps she is deceiving us by seeming to be so scrupulous? Taiku, this question shall stand unresolved, meaning case by case basis, the judge is going to have to make a ruling. We don't have a precedent there. Another dilemma was raised before the sages. In the case of a woman who reduces her marriage contract by saying that its sum was less than the usual amount or less than the figure specified in the document, what is the law? Do we say that this is like the case of a woman who vitiates her marriage contract and the law is the same in both cases? Or perhaps there is a difference between the two cases because a woman who vitiates her marriage contract admits that she received part of the money owed to her, whereas this other one does not admit to part of the claim. Here she claims that she has received nothing at all, but that she is owed less than what was initially thought. The husband says, okay, I owe you 1,000 dinars under our marriage contract. She says, no, actually, our marriage contract was for 500 dinars. So, does she need to swear an oath to receive that 500 dinars because it's like she's saying she already received 500? It's like that, but that's not what happened. In the case where she already received 500 and she says I received 500, now I want my other 500, she has to swear an oath. But in this case where he says, okay, I think I owe you 1,000, and she says, no, you only owe me 500, that's not the same as I already received 500. So maybe in this case, we don't make her swear an oath and we just give her the 500. So the Gemara suggests, come and hear a resolution from a baraisa. One who reduces her marriage contract can collect it without an oath. How so? If her marriage contract was 1,000 dinars and her husband said to her, you have received your marriage contract, and she says, I have not received my marriage contract, but it is only 100 dinars, she may collect it without an oath. So the Gemara asks, if her claim is accepted, with what does she in fact collect payment? With this marriage contract document? This document is merely a shard of earthenware, as she herself admits that the document is not a valid document because it records a fictitious sum. So Rabba, the son of Rabba, said, it is referring to one who says, there was an agreement of trust between him and me that although the marriage contract records a large sum, I will claim only part of it, but the document itself is genuine. So in that case, she takes the amount that she says was actually meant, even though they recorded a larger amount for whatever reason, and she collects that without an oath. The Mishnah teaches, and I'm almost done. If you have questions or comments, please get them in. The Mishnah teaches that if one testifies that the marriage contract was paid, she must take an oath. Rami Bar Chama thought to say that this is an oath required by Torah law, as it is written, one witness shall not raise up against a man for any iniquity or for any sin. One witness shall not rise up against a man for any iniquity or for any sin. Now from here it is inferred, it is for an iniquity or for any iniquity or for any sin that he may not rise up. Meaning, the testimony of one witness is not enough for these purposes. But we do accept the testimony of a single witness to rise up for an oath. It can create enough doubt in a situation that will demand that one of the litigants swear an oath. We won't establish guilt or a debt by the testimony of one witness, but the testimony of a single witness can create enough uncertainty that we demand an oath from one of the litigants. And the master said, in any place, i.e. situation, where two witnesses are able to deem one liable to pay money, the testimony of one witness obligates the litigant to take an oath. Rava said, no, there are two answers in the matter, in refutation of your argument. One response is that anyone who is obligated to take an oath that is enumerated in the Torah takes an oath and does not pay. By Torah law, one takes an oath only to exempt himself from payment. And in this case, she takes an oath and receives money. So it must be by rabbinic law, not by Torah law. And furthermore, there is a principle that one does not take an oath with regard to a denial of a lien on land. Rather, said Rava, this oath was instituted by rabbinic law in order to put the husband's mind at ease. Since a witness contradicts her claim, the sages imposed an oath upon her so that the husband would be sure that he is not giving away his money for no reason. That's a rabbinic ordinance, not by Torah law. And as you can see, it promotes peace in a community. All right, let's see if there are any questions or comments on this Kesubos Daf Pei Zayin, page 87. Okay, so Nina is telling me no questions or comments on the daf. Okay, beautiful. Must have been super clear. Okay, my friends, may you be blessed to have a fantastic week coming up that includes Yom Kippur. It should be meaningful and uplifting and elevating. God willing, we'll be together again tomorrow night, the regular Sunday time, 6 p.m. Pacific, to cover page 88.